this presentation. This gives us the impression that we have also alternative facts to discuss sometimes. And I now give the floor to our colleague from Germany, Daniel Thym, a professor at the University of Konstanz.
Okay. No, many thanks, Philip. And many of us are involved with the reform of the common European asylum system in one way and another. And in doing so, we tend to focus on the detail, the nitty-gritty of detention conditions or the Dublin procedure. And all that is, of course, relevant. And nonetheless, we should not lose sight of the broader picture, which is particularly relevant at this juncture, why the EU's asylum policy suffers from structural deficits. And I will focus on 4 of these structural deficits today, and I'm doing so in a constructive manner. Understanding why we are in trouble may ideally help us to overcome the ongoing policy crisis. Firstly, the role of legislation. For many of us, European integration proceeds by way of legislation and court judgment. And asylum is no exception. The construction of the common European asylum system has been essentially a court-driven and legislative development. Academics, commission staff, MEPs, we all focus on how to design or interpret legal rules. And of course, and one of the lessons of the past year is that this is not enough. We have several hundred pages in the official journal which should have prevented or at least mitigated last year's crisis if only they had been applied effectively. Relocation, for instance, doesn't work. And arguably, this lack of effective implementation may be explained, in part at least, by the operational character of asylum and border control policies. They habitually involve the application of rules to thousands of cases by officials with a relatively low degree of formal education. Think of the protracted difficulties in setting up humane hotspots. And I've argued elsewhere in a recent article for the Common Market Law Review that this operational character explains why the traditional method of integration through law, with its focus on legislation and court judgments, which has underpinned the success of European policies in many areas, doesn't work in areas such as asylum and border controls. We need new mechanisms to realize European policies. If the law isn't applied effectively, member states will not trust each other, and without trust you will never get solidarity. And this vicious circle has to be overcome, and that is why the agencies are so crucial. Their success may not be guaranteed, but they are the best tool we have to ensure that policies agreed upon here in Brussels are applied in the field. And the institutions are right, therefore, to prioritize the substantial strengthening of Frontex and EASO. In short, legislation is not enough. Second, what else went wrong? Among the structural deficits which explain the crisis, the flagrant solidarity deficit epitomized by the Dublin regulation stands out. And yet we should be careful not to put all the blame on Dublin only. Why? Some member states do not have much experience as asylum destination countries and may lack the administrative capacities or the political will to establish functioning asylum systems. To put it bluntly, some of the frontline member states are disadvantaged by Dublin, but they also have obligations which they do not always fully respect. Even if the EU could agree on a purely hypothetical quota system for all member states excluding the UK and Ireland, a distribution key based on GDP and population size would require Greece to host 1.9% of the roughly 2 million people who entered over the past 2 years. That is 38,000 people for Greece only a bit less than there are residing at the moment. And the Italian share would be roughly 14% or 280,000 people. And it's not clear whether we have 280,000 places in compliance with the Asylum Reception Conditions Directive in Italy. Fixing Dublin, fixing the solidarity problem would not be enough. We also have to enhance administrative capacities on the ground. And again, that is why the agencies are so important. Third, migration management. I agree with Thomas that states have limited capabilities to control cross-border movements. The idea of simply closing a national border is an illusion, especially for states which respect human rights. But I think Thomas is wrong when he seems to suggest that state measures have no impact. They can be relevant, since mobility is never absolute. There are facilitators and there are hurdles, and some of which can be influenced by state. And it seems to me that the Eastern Mediterranean is a case in point. It may be correct that the numbers of arrivals was already in decline when the EU-Turkey statement took effect. But from the perspective of rational choice theory, that means economic theory explaining human behavior, less people will invest money in trafficking or risk their lives on the Aegean if they know that they might not achieve their objective. That's rational behavior. State policies can matter, although the degree of influence will always depend on contextual factors. And which are these contextual factors? Sociological studies show that migratory movements are complex phenomena which are influenced by many variables. And many of these variables are beyond the direct reach of destination countries. If that is correct, a smart policy design will aim for a multidimensional response covering several aspects of the migratory journey from departure to arrival. And that is what the EU is doing under the new partnership framework mentioned earlier. Border controls alone will never do the trick, but a multi-pronged approach covering several stages of the journey may yield more success. And from a normative perspective, such a policy is less problematic in situations of so-called mixed flows, comprising both those in need of protection and others, as currently in the southern Mediterranean. In such a scenario, it can be legitimate to distinguish early on between those in need and others, in line with the dual objective in EU primary law, the treaties, to respect the refugee protection and, let me quote Article 79 TFEU, to pursue enhanced measures to combat illegal immigration. In the central Mediterranean, these legally binding treaty objectives overlap, and it's understandable in my view that the European Council tries somehow to balance them by emphasizing the need for cooperation with neighboring countries. Although I should add that I personally would be more convinced if the EU emphasized more clearly that it also aims at furthering refugee protection, be it in Europe or elsewhere, instead of simply stating, as the European Council nowadays sometimes does, that it only wants less arrivals and more returns. And talking about legitimacy brings me to my last point, politics and the law. This is a conference organized by a network of legal experts, and we all know that the law plays a prominent role in policy debates. And in that respect, it may be helpful to distinguish the double function which the role can play and the EU treaties can play, because they serve on the one hand as a legal limit which can be enforced in courts, while being invoked on other occasions as a constitutional value, and a value can guide policy choices even in the absence of strict legal obligations which can be enforced in courts. And this may sound very academic, very abstract, but it can have practical repercussions, as a very brief example shows. You may be familiar with the safe third country provision in Article 38 Asylum Procedures Directive, which requires at the moment that a refugee has a personal connection to a state to which he is returned. And this could change, however, if the legislature decided to discontinue the personal connection criterion in the future asylum procedures regulation, which is currently being negotiated. While closer inspection shows that the personal connection is not mandatory under neither the Geneva Convention nor the ECHR, as both state practice and statements by UNHCR and its executive committee demonstrate. the legislature has to make a political choice. It cannot be sanctioned by the ECJ if it abandons the personal connection criterion. And it seems to me that this situation is not unique. The EU treaties limit political discretion without undoing it. Lawyers alone, that means many of us, we will never be able to build a sustainable asylum system. That requires political choices, and there are important legal details which have a massive impact on what can be done in detail, but the general orientation needs to be a political decision. And in taking these decisions, the EU institutions shape and decide and transform the values which define the EU and its asylum policies, and these values are reflected in the EU treaties, but they do not come out of the blue. They need to evolve on the basis of political choices and social practices by deciding, for instance, how generous a safe third country provision is. The EU treaties will not resolve this query legally. They entrust the political institutions to do so. Thank you.